Good morning, Ms. Zizza. You may proceed.
Good morning, Your Honor. We are here today because the appellate court overturned a Superior Court decision for dismissal under 12b-10, which is want for procedural amount of $25,000. And the issues before the court today, The issues before the court today is whether or not the Superior Court is the correct forum for a claim seeking equitable remedies in the form of injunctive relief.
But can't you get the equitable relief that you seek in the district court by an attachment or some other post-judgment proceeding if you prevail on your legal claim?
Your Honor, my legal claim is for specific performance. In my brief, I cited 23 cases.
No, okay, but it seems that your main claim is against the person who hasn't paid you, so it's a breach of contract. Is that right?
Hasn't paid me and will not continue to future pay.
Correct. So that's a breach of contract.
Yes.
So then if you could go to the district court and get a decision in your favor that he has in fact breached the contract, then there are proceedings in the district court whereby you can have have his wages attached, meaning, taken from him and given to you before he ever gets them.
Well, Your Honor, I did go to the district court, and in the district court, I was awarded arrearages only. And in fact, Attorney Gleason argued that the court could not give me the relief of future compliance because that is the remedy of specific performance, which belongs in the Superior Court. So one of the defendants in this case, in fact, argued in district court. The district court gave me a judgment on the arrearage portion only. And at that point in time, I did extensive research. What would be the correct forum to bring this case to make future payments?
So is your action in the Superior Court, was your action in the Superior Court only for future damages?
It was for arrearages from the time that the district court amount was satisfied to the time I filed in the Superior Court, and as well as future damages.
Did you ask the district court to order Mr. Zizza to apply for a wage assignment through his employer?
No, Your Honor. There is a wage assignment, which is in the appendix. There's actually two of them, which requires his employer to comply. And his employer...
No. My question was, did you ask the district court to order him to request that they assign his wages directly to you?
No, Your Honor. At that time, they were assigned directly to me, so I didn't have to ask.
Okay. Is there some question that the district court does not have the authority to order him to apply to his employer for a wage assignment?
Yes, Your Honor, because it's specific performance. And Attorney Gleason filed a motion stating that the district court did not have jurisdiction because the relief I was seeking was specific performance. Specific performance is an equitable remedy, and that equitable remedy is only available in the Superior Court. That was Mr. Zizza's attorney's own motion.
Ms. Zizza?
Yes.
This is a factual question, and I probably should know it, but the argument is made on the other side that as of 2004, there is no agreement for a wage assignment. Do you disagree with that?
I absolutely disagree. And if you look at the conduct of the parties as well as the appendix, it actually has been complied with until June of 2000.
But it's true that in 2004 a new agreement was entered that superseded all previous agreements by its terms. Isn't that correct?
Well, no, it didn't supersede. It incorporated prior agreements. The amount per week was still $262.
Right, but isn't there language in that, at least it's quoted in the brief, as saying this shall be it's an integration clause. That I'm now looking for it in the appendix. But I thought that sort of became the agreement.
Well, no, Your Honor, because we continue to comply with the wages.
Well, I understand that, but just in terms of written, I mean, not looking at conduct, but just in terms of what is written, in that 2004 agreement, is there any language that provides for a wage assignment?
It provides that $262 a week will be paid from his wages, period. So it doesn't state the employer shall do it. And that language was put in there because at that point in time, the employer was already taking it out of his wages and forwarding it on a weekly basis. When I applied for relief in district court, at that point in time, Mr. Zizza then was started paying for a short time again, so it was just 2 arrearages. It was after the district court judgment was finally satisfied that he stopped paying yet again. So that's why, while in district court, I didn't have to ask for a weekly wage assignment because he was complying. On the second incident in district court, when his car was seized for non-payment, he was then collecting unemployment, so his employer wasn't sending it at that point in time. Once he got his car back, he returned to work, and that's when all payments continued to not be forwarded. Did that address your question, Your Honor?
Yes, thank you.
So,
So what do you see to be the consequence of 19C?
well, Your Honor, in regards to 19C, it specifically states that the Boston Municipal Court departments and the district court shall have the same inequitable powers and jurisdiction as provided with the Superior Court pursuant to 214, and the same authority with regard to declaratory judgments as is provided for the Superior Court pursuant to 231A. For the purpose of this hearing and disposition, summary process actions and civil actions for money damages is under 17. Under section 19. It's for money damages. They're telling the district court you have the same equitable powers in regards to a declaratory judgment and for money damages. I'm not only seeking money damages. I'm seeking relief for future damages. I'm seeking an order that requires the 4 corners of the contract to be enforced, because it's very clear if that's not done, I will be in court every few months.
But if this court were to say that in district court, if your claim is for less than $25,000 in money damages, the district court has full equitable power, that would satisfy you, I trust.
It would, Your Honor. I'm looking for the correct court. When I was in district court, the defendant's attorney...
You're looking for the order that says to this person who constantly is falling behind in his payments, you pay as the contract provides, or else you will be in contempt of court.
Yes, Your Honor.
And you don't care if it's the United States Supreme Court, the Supreme Judicial Court, the Boston Municipal Court, the Housing Court. You want to hold somebody accountable for the contract that they entered into, and you don't want to have to come back to court again and again and again.
Yes, Your Honor, and that's what's been happening. As I was in the district court, then they argued that specific points should be in the Superior Court. We went to the Superior Court, and it's notable that Attorney Gleason did not even raise as affirmative defense 12B10, so it was considered waived. 2 months after he files his answer, he files a motion under 12B10. Well, 12B10 is waived if not pled in an affirmative defense or in the alternative timely motion. So it was perceived as waived. Then they make the argument, oh, it has to go in family and probate court. Well, it doesn't have to go in family and probate court because there are also claims against Mr. Zizza's employer and a specific agent of his employer, Michael Thompson. Those could not be adjudicated in family and probate court. All I want is one court that all these defendants can have jurisdiction over and the remedy that I'm seeking.
Did the district court judge say, either orally or in writing, that he didn't believe or she didn't believe that the court had equitable powers to order him to do the wage assignment?
Your Honor, that wasn't even an issue because at that time it was just arrearages. He was paying every week. So
okay,
the issue of continued payments was not at issue. At that point in time, it was just for arrearages. Right. And it wasn't until... I think if you read in the packet, you'll find that on, I believe it was July 15th, we reaffirmed the obligation of the $262 a week. I assumed we were all set.
Why didn't you go back to the district court and ask for an equitable order? Did you think that the court did not have the power?
Yes, Your Honor. After Attorney Gleason filed a motion saying that this is a remedy for specific performance for future payments and it belongs in the Superior Court, I did extensive research. You will find in my memorandum I cite 23 cases. in regards to marital agreements that survive as independent contracts. Those 23 cases all say Superior Court is the correct form, specific performance is the correct remedy.
Well, that was before the statute was changed?
No, Your Honor. Some of those cases are after the statute was changed, and there's extensive case law. So I did not file in Superior Court in bad faith. I filed based upon the 23 cases that I researched that said that this is the correct form to go before. So that's how I proceeded forward accordingly, because that's what the case law stated was the correct way to go. I did not arbitrarily decide, oh, I'll go in district court. Oh, now I think I'll go in Superior Court. District court was purely for arrearages. He was paying every week at that point in time, except for the arrearages. And it wasn't until he stopped complying in its entirety that I had to file in the Superior Court. So with that being said, Your Honors, the 23 cases that I cited, I believe it's abundantly clear that the Superior Court is the correct jurisdiction. If this court finds no, it is the district court, obviously I would file in district court. It's notable that Judge Whitehead's when Judge Whitehead dismissed it, he had stated that he didn't see the damages exceeding $5,000. At this point in time, Mr. Zizza is almost $16,000 behind. In 4 months, I'll be able to file in Superior Court anyway because I'll be at the $25,000 threshold. It's exasperating. It's not going down. It's not a damage claim in the true sense where this is the number, this is what's going to say. Every single week, that number is getting bigger and bigger and bigger. And there's tort claims in regards to his employer and Mr. Thompson. There's also some contractual claims against them. And, you know, if it was up to the defendants, these claims would be fabricated, one as to Mr. Zizza and one as to the employer. But their actions are so cohort in nature and intertwined that it really needs to be heard all in one court, one resolution, one finality of the entire case.
Are you opposed to proceeding in the probate court?
I am, Your Honor. The probate court does not have jurisdiction over Michael Thompson or Plastic Concepts. And the 23 cases which I cite in my brief are very clear. I am entitled to relief under breach of contract. I do not have to subject myself to the family and probate court for Mr. Zizza and then file against his employer, whether it be the district court or Superior Court, and have to then litigate 2 claims in 2 different forums.
Thank you, Ms. Zizza.
Thank you.
Good morning, Mr. Cossingham.
Yes. Good morning, Your Honors. My name is Attorney Ken Cossingham. I represent Mr. Zizza's employer. Mr. Boland is with me today, and he represents Mr. Zizza, so we will split our time, and I'll yield about halfway through. Much of what you've heard, as I mentioned in my brief, much of what you've heard today, much of what is in the appellant's brief goes to the merits of the case, and I suggest is not properly before the court. What is before this court is the proper operation of the one-trial system. What we have is a situation where there's a Superior Court claim that has a legal claim that is less than $25,000 and also has an equitable claim. And whether or not that equitable claim forces that legal claim into the Superior Court is what's before this court today.
And why doesn't
Is it your view
it?
that there's any place for one-stop shopping for her?
I'm sorry?
Is it your view that there's any court in which she can do one-stop shopping?
Yes, absolutely.
Which court is that?
She has the absolute right to pursue her claims against Mr. Zizza. Well, first of all, let me go back
About your
one step.
client.
I'm sorry?
How about
And
your
my
client?
I'll address that. There's no doubt that the Superior Court has jurisdiction. We're not saying the Superior Court doesn't have jurisdiction.
Doesn't that end the case?
Yeah.
No, it's not. Because
Why?
under 212.3, a claim for money damages, there's original jurisdiction in the Superior Court, and 218.19, there's also original jurisdiction in the District Court. So both courts have non-exclusive original jurisdiction.
Then there's
The only question is 212.3 says that if the likelihood of recovery is not going to be over $25,000,
likelihood is
then it
pretty-
shall not proceed, even though there's
The
jurisdiction.
likelihood is pretty high at the moment, as I understand it.
Well, we would disagree with that, and I'll let the
But
employers. But that's not before Your Honor, as you know.
even if that's the case, if the court has jurisdiction, let me put it this way. Tell me what in the appeals court decision is wrong as a matter of law, not a matter of policy, as a matter of law.
What is wrong in the appeals court decision is Justice Rubin is saying that because there's pending jurisdiction, it has to be in the Superior Court.
Did
That
Mr.
ignores-
Zizza file a motion in the district court saying that the district court didn't have jurisdiction to provide specific performance?
I'll let Mr. Zizza's attorney address that.
No, but do you just know? It's a factual matter, yes or no?
There is a pleading in the appendix that does make that claim.
Okay.
It's wrong, but there is a pleading in that appendix, and I'll let Mr. Zizza's attorney
So your
address it.
view is
back
that
to
she can
Judge
go to
Gann.
district court and she can get equitable relief there?
Yes, absolutely. As you stated, under 218-19C, if the claim is for money damages, and Justice Whitehead of the Superior Court found that's exactly what this is, a claim for money damages, the district court has full jurisdiction, the full jurisdiction that Superior Court has under 214.
So if she goes to district court and seeks equitable relief, you say she is not entitled to it as a matter on the merits, but you, the district court, have the authority to award her equitable relief if you find that her claim is meritorious. That's what you will say to the
That's right. It's
district
within
court?
the authority, and now
And
we'd have
against
to
your
reach the
client as
merits.
well? Not just against Mr.
Sure,
Zizza, against your client as well?
Sure, because it's a claim for money damages. Justice Whitehead indicated that what
That's it.
I'm sorry. She can file in the district court. It's a claim for money damages, so there's full jurisdiction in the district court with full equitable powers in the district
And
court.
where, show me the language about the full equitable powers in the district
It's
court.
218-19C. 218-19C.
Now, and she says that at least she's done some research that indicates that we have said that cases in which there is sought enforcement of a separation contract, a marital separation contract, that those don't belong in the district court, that they should only be heard in the Superior Court. What do you say about
That's
that?
a misreading of the cases, because many of those cases were prior to the one-trial system. As you know, the one-trial system came in being in throughout the
Were all of
Commonwealth
those
in
cases
04.
Were all of the cases prior to the one-trial system?
Not all of the cases.
So there are cases afterwards that say the Superior Court?
None of the cases say it has to be in Superior Court.
No, but it's appropriate to be in the
No,
Superior.
no. What she's citing those cases for is the Superior Court has jurisdiction over contracts between former spouses. And it's true, because those contracts are claims for money damages, so under 212.3, the Superior Court has original jurisdiction, but under 218.19, the District Court also has original jurisdiction.
Mr.
So it's not
Cossingham.
a question of jurisdiction, I would respectfully suggest. The one-trial system says in order to properly utilize judicial resources, we're going to give the same jurisdiction to both levels of the court and separate the cases with the $25,000 line, and these cases below the $25,000 are tried down here. It doesn't divest either court of jurisdiction, but it does say these cases shall not continue. Under 212.3 and 218.19,
Show me the language in 218-19 that gives the district court power to,
19C.
It's not just show, Mr. Cossingham, I'm sorry, none of you have put statutes in our briefs which the rules of appellate procedure
I'm
require.
sorry.
That's okay, but so you say 19C and then I go look to it and it's not here. So tell me what it says.
Okay, it says, the district court, and I'm going to skip over some portions of it, shall have the same equitable powers and jurisdiction as provided for the Superior Court pursuant to Chapter 214, the very same powers. And then it goes on to say, and the same authority with regard to declaratory judgments. So if I take the first part of the phrase, the district court shall have the same equitable powers and jurisdiction as provided for the Superior Court pursuant to 214, in reference to claims for money damages. If it's a claim for money damages, which Justice Whitehead of the Superior Court found it was, then the district court has the exact same authority as the Superior Court. Now, the only reason to give the district court those equitable powers is if the Superior Court can act as the gatekeeper and can assign to the district court those cases that include equitable claims that fall within claim for money damages. It doesn't make any sense to give the district court equitable powers, as the legislature did, if they can't deal with cases that are both equitable.
So are you saying that the only problem here is that the plaintiff just didn't go back to district court one more time?
No, not at all. I'm saying that under 218.19C, and 212.3, which together is the one trial system, the Superior Court has the authority and the discretion to act as the gatekeeper.
Okay, so what happens if she goes back to the district court now? What's your defense going to be? What are you going to say in district court?
Then we're back to the merits.
Why
Why
does your client care which court you're in if both have jurisdiction?
Yeah.
Because the proper operation of the one trial system allows the Superior Court to assign smaller cases. Justice Whitehead said this is a small case; it can be better dealt with.
I understand,
in
and
district
so,
court.
but let's assume that we disagree with that. Does it make any difference to your client? Are you going to get a fair hearing? You're going to get a timely hearing?
No, we suggest that under the law, that's the proper venue. It's like a venue argument.
Thank you,
And
Mr.
I'll yield
Cossingham.
to, Mr. Bowles.
Well, you can't yield because you've gone over your time, but it's fine. Good morning, Mr. Boland.
Good morning, Your Honor. May it please the Court, William Boland appearing for the defendant in this case, in behalf of Attorney Gleason, who was unavailable.
Did your client file a motion to dismiss in the district court saying that the district court didn't have jurisdiction to issue specific performance?
Judge, I'm not aware of that, to be honest with you.
It's in the
I mean,
record.
is it in the record?
It's in the record. Didn't he say it's in the record?
It's in the record.
Yes. Then I'll retract that, yes.
So he did.
Yes.
Fine. So he says, I want to be in the Superior Court.
Well,
No, wait a minute. He says that. And she goes to the Superior Court, and there's case law that says the Superior Court has jurisdiction.
Judge, we're going to mix metaphors here. We're talking about specific performance.
Right.
And I think the question in front of this honorable court is what specific performance is. Judge Whitehead, when he made his decision relative to dismissing this case under 12B-10, state that there wasn't any equitable claim filed, a proper equitable claim. So he dismissed it. As a matter of right, he dismissed the claim. Our position, Judge, and I may pick up on something you said, we don't care what court we're in, but we'd like to be in the probate court. And the reason we want to be in the probate court...
But she can't, could she adjudicate her claims against plastic concepts in the probate and family court?
In theory, yes.
What do you mean in theory?
Well, in every day in the probate and family court, Your Honor, as you know, there are people that are brought forward for child support. They have exclusive jurisdiction and original jurisdiction on issues relative to divorce, child support, enforcement.
This is a contract claim.
There's a contract claim.
Yeah.
Correct. But the contract is illegal. It doesn't exist.
But these Chapter 119, section...
The contract is illegal?
Yes, it is, Judge. That's our position.
What do you mean it's illegal?
The contract is illegal. The contract is relative to future payments for children and child support. Massachusetts law does not recognize that. You cannot merge, you have to merge those kind of contracts. It cannot survive independently as a contract to be enforced in a different court. You cannot, as my understanding in the case law will support this, you cannot discourage or fragment away
Well, we
Charles-
certainly have cases that say that the party can't, as a matter of independent contract, the party can't, a parent cannot agree not to pay child support.
I think the case law, Judge, says that you cannot waive away your child's interest. In other words, the contract can't be an independent contract. It has to be merged where the jurisdiction of the probate court can put its tentacles into it, where you can argue, where you can bring complaints for modification, where you can examine both parties through financial statements. You can put a completely different spin on it if it's in probate court. And I would suggest to the court the reason that it's not in probate court because that opens it up to interpretation and modification.
If that's the case, then how was it that your client entered into that agreement with her?
Well, two respects. My client entered into the agreement a long time ago. He was not represented by my office. The divorce happened in the...
Have you filed a motion to transfer this case to probate and family court?
Have I? No. No.
Well, then how on earth can I mean, all I'm deciding here is whether you may have defenses in the Superior Court.
Well, but to answer your question, the divorce happened in the Dominican Republic, and it has never been memorialized in any state court.
We don't need to memorialize divorces in state court.
Well, you have to process them through the state courts. If someone's going to take jurisdiction over the divorce, it's my understanding that...
We enforce divorces that are entered into in other countries, Canada, Mexico, Dominican Republic, England, Australia, Italy, Ireland.
True. I
You don't have to come here into Massachusetts and say, I was divorced there, please recognize the divorce here.
But I use the term memorialize, but to bring it forward into the a domestic situation in the Massachusetts courts, that would open it up for interpretation by either a magistrate or a judge.
If we conclude that either the Superior Court or the District Court has jurisdiction, let's assume we do what Mr. Cossingham wants, which is to say it's only in the District Court, and he seemed very happy in the District Court, and that's where everybody seems to want to push this case. I assume that you will raise there whatever defenses you think your client has to this contract.
That's correct.
Well, that's the appropriate time to raise it. That doesn't resolve between the Superior Court and the District Court.
I understand, but the Superior Court has the jurisdiction over equity, as we understood as my...
And if we disagree with Judge Whitehead that this is in effect a request for specific performance, correct?
Correct.
Then the Superior Court has jurisdiction, and then tell me why the Appeals Court was incorrect to say, in the same way that we have all kinds of cases in the federal courts, for example, where they have, there's a whole body of rules which says when a court can assume jurisdiction over a piece of the case that it might not have had jurisdiction over to begin with. That seems to me the basis of the Appeals Court's decision.
Well, if I can answer that, Judge, I believe your question pertains to the color of the claim, the equitable claim. Judge Whitehead determined that there was not a equitable claim stated under 12b-6. And I am not saying that the Superior Court doesn't have jurisdiction over equitable claims, but the mere fact that there was no claim stated is where Judge Whitehead made his decision. And I concur with that. There is no specific performance. As you know, Judge, in this, Your Honor, specific performance is not a right. It's a remedy. And there's other remedies available before specific
If somebody
performance.
if somebody, and I'm just assuming, and I'm not saying that they have been proven, but let us assume that your client has an obligation to pay a certain amount of money every month, and your client does that, then falls behind, then the enforcing party goes into court to get a back award, but knows that he's going to refuse to pay in the future or decline to pay in the future. Why is that not specific performance? What's the case that you're telling me is not specific? An order that he comply with the terms of the contract, why is that not specific performance? What's the case? Judge Whitehead didn't give me a case. What's your case?
Well, specific performance in the the analysis of specific performance is something that is special. It can't be done other ways. There can be no other remedy. Land, for instance, buying land that a certain piece of land on Beacon Hill or something, or buying Fenway Park and then reneging on it, you have no further remedy.
Well, she needs weekly support, and how
understand
else
that.
is she going to get it other than from Mr. Zizza?
She's going to get it from Mr. Zizza.
But he's not doing it.
this
So
point, he's
the way
not
you
doing
do
it.
it is
Yeah.
to go get an order that the employer deducted from his pay.
But that hasn't been determined in the correct form of what that is.
It
And
can
you
be
s- and you
determined in the
said-
Superior Court.
It could be, yes.
It's the correct forum.
It could be, it could be done in the Superior Court, but the enforcement of that, it's a direct contract action at that point. It can't be modified in the Superior Court. It can't be challenged in the Superior Court. It can't be analyzed in the Superior Court.
She doesn't want it modified. She wants it enforced in the
We
Superior
don't know
Court.
what that modification is going to consist of.
What
We
modification?
We challenge the number. There's a
It
certain...
can be,
An
that can be
agreement that says that's
determined
what
in the
you're supposed to
Superior
pay.
Court.
No, that's not necessarily true, as I mentioned, because...
But that's a defense. Isn't that a
Defense.
defense? Well, then you raise the defense in the Superior Court.
It's a contract action.
It is a contract action. A specific-
She's saying a certain amount is owed as of a certain date. You're apparently saying it's not.
But I'm
That's the stuff contract actions are made of.
The contract action, again, with the jurisdictional amount of $25,000, Judge Whitehead has determined that it's less than $25,000. So that kicks it back automatically. What the plaintiff is saying is she's looking out into the future and interpolating monies out into the future and saying, well, I can get over this hurdle of $25,000 because it's $262 a week times 4 years or 5 years. I think that's an invalid argument. And we would address that in the probate court, as we do on a daily basis. That's where this case belongs. Let me ask you, if this court were to say it goes back to district court, and if Ms. Zizza were to ask for arrearages and an order of the district court requiring you to pay weekly payments pursuant to a contract that it finds to be legitimate, Yes. are you going to be telling the district court, you not merely she's not entitled to that in the merits, but you don't have the jurisdiction to issue that order? No. So you agree that the district court has the jurisdiction to order specific performance in this case? Absolutely. But we would raise defenses in the district Well, court. I understand that.
Thank you,
Thank you very much.
Mr. Boland.